So you've written a column. Are you going to be touching on probably the news of the week, which is the Zimmerman trial?
Yeah, that's an interesting trial taking place because, and I don't know what's going to happen. It looks like he's made an awfully strong case to oppose reasonable doubt. Not a question whether he's guilty or innocent. You're a lawyer and I'm a lawyer, and for you listeners who don't know this, you don't have to show he's guilty. You just have to show that he's guilty beyond a reasonable doubt. And of course, the prosecution has allowed some witnesses to come in there and put some reasonable doubt in who was really on top, who did the screaming. And it's a tough case because either way this case comes out, there's going to be a lot of bitterness and a lot of controversy. And I'm afraid, too, Steve, that there's going to be some degree of a black-white issue involved here, like we saw after the O.J. Simpson trial. I wish that weren't the case, but we're probably going to have a tinge of that in there. What I'm concerned about is that they just don't lay out all the evidence. There was an effort, for example, to let state officials come in and give their interpretation as to who was talking. And the judge says, oh, no, we can't have that. You can put Mama's opinion of Martin and Mama's opinion of Zimmerman, but you can't have the experts come in. And that's too prevalent in this country. And look, there's not a worse abused system in the world probably than in New Orleans, where the prosecutors routinely hide evidence that could help the defense. So I don't like that. Lay it all out, and let's let the chips fall where they may. And that's probably a good column for next week, quite frankly, about some of the cover-ups that happen in New Orleans, particularly in the federal system down there.
So just to play devil's advocate, should we have double hearsay come in?
Double hearsay? Well, you can make an argument.
You don't have to answer that. I'm just, you make a good argument. And being, the judge is going to listen to what in this case, she thinks is admissible or not admissible. It's a tough call, and no matter what people are going to criticize.
I have seen such an abuse where the pendulum has swung the other way, where prosecutors keep out a lot of exculpatory information, that I'm almost willing to try a system where you let it all hang out. A juror in their home makes a decision about buying a house or where they send their kids to school. They make what they think is the best decision based on what they read, what they hear, what their neighbors say, and by and large, we make a pretty darn good decision. I'm not sure I wouldn't want to try it out where you could go home and read the paper and talk to your neighbors about the case and listen to the evidence, and then if it's secondary hearsay, that's the job of the other side's lawyer to point that out. But let all of your empirical knowledge say, okay, I've heard everything, I've talked to everybody, and here's what I think would happen. Then you get 12 different views to bring that about. So I'm so frustrated by the abuses on the part of prosecutors that it may be a good idea to let it all hang out, put it all out there and see what happens. So we'll see what happens in this case, though, with great interest. But in any event, this trial is going to, because so much interest, is going to be a riveting trial. I don't think it'll reach the level of the O.J. Simpson trial, but I've seen it broadcast on 5 or 6 stations at night, replays all over the country. So America is certainly tuned in, and maybe we'll see some ways to tighten up the law in some way. This self-defense issue is going to be debated a good bit. So we as lawyers will be debating this case for a long time to come.
Yeah, I personally have some real questions on both sides. I can see a darn good argument from the side of the defense, but then I likewise, if you really focus down, I can see it from the prosecution also. I don't think it's a slam dunk as everybody's been saying. At least the people I've heard on TV, etc.
Well, first of all, for goodness sake, Zimmerman, when the police officer tells you to get in the car, help's on the way, do what the police officer says. You might second guess him later, but you're in an enclosed community. Martin couldn't run anywhere. He was completely enclosed, and so that has destroyed one life and is going to have a massive impact on families in this whole multitude of things. So he just didn't follow instructions. So I may disagree with those instructions, but unless you're in danger or there's some real loss there, if he'd have done what the police officer said, we wouldn't be debating all this thing right now. But it happened, and now you've got to kick the law in, and it'll be an interesting interpretation of the self-defense law, where when you think you are in great danger, you can take that action. And boy, like I say, both sides,
Sure.
whoever wins, the other side is going to be deeply, deeply unhappy about it.
Yeah, actually, from my standpoint, if I were in a jury, I think the question I would ask, and to me, it's the ultimate question, and I'm not sure that anybody has really posed it, but at least to me, the question I would ask is, if I were Zimmerman, could I have done something else at the very last moment? Did I use force that was appropriate? And I don't know the answer to that, but I would apply that to the law, to the facts of this case.
Well, if it were in fact true that he was on the bottom, his head's being banged against the wall, you've got a much larger individual, as Trayvon Martin was, threatening him in some pretty vicious ways. If all that were true, then under Florida law, I think I could make a case as a defendant that he was trying to save himself from having his head bashed in. So, but who knows if all those facts are true or not? I don't know.
Sure, and exactly. And so let me just posit this, and that is that with his experience in criminal law, apparently, he obviously took quite a number of courses and wanted to be a cop, and failed to be. But so he's carrying a gun. And if in fact Martin is on top of him, and his head wasn't all banged in, I mean, he had some look like a contusion or abrasion. Not that I would want to have any of that done to me, but I have a gun, and wouldn't I just go ahead and just say, look, you do anything more and you're dead? At least with that kind of knowledge that he would have, and with that kind of power in his hand, wouldn't he have an opportunity to at least, just like in an automobile accident, the person has the last chance, and he had the last chance, and he blew it.
Well, but if someone's grabbing it, you're on top of you and pounding you down, and you get your gun, I mean, someone's right there in your face. Do you have the opportunity of saying, look, you better back away, I got this gun? I mean, in a split second.
That's where the facts